Hi, and welcome to Brett's Corner, where we cover everything small business. From how to start a business, to how to grow your business, to how to keep your books, and ultimately how to position and sell your business, and some things to think about after you've sold your business. If you're a small business owner, or you're thinking of being a small business owner, you're in the right place. My name is Brett Husselball, and I've been a small business owner for over half my career. I started my first small business in 1995. I quickly grew that one to over multi-millions in revenue, and I sold that to a Fortune 500 in 1998. I started my second small business in 2000. I grew that one more slowly to over $1 million in revenue, and I sold that to a multi-billion-dollar corporation in 2014. And now I'm retired. And what I like to do here at the Corner is to share the benefit of my experience with you. So, before we begin, a quick disclaimer. Number one, I'm not an attorney. I will share with you some of the experiences I've had regarding legal issues and what worked for me, but what worked for me may not work for you. If you have specific legal questions, consult an attorney. Number two, I'm not a CPA, nor am I a certified financial planner. But like every business owner, I know my financials, and we'll talk financials, and I'll share with you some of the things that you should know. But if you have specific financial questions or tax questions, consult a professional. Same goes with investment questions. Consult a professional. So, with that out of the way, let's get on to today's video. Hi, today I'd like to talk to you about doing business with large corporations, or large entities for that matter. Large companies are going to require you to sign some sort of master agreement before you do business with them. If you're doing services for them, it's going to be a master services agreement. I highly recommend that you personally read that agreement. If it's 10 pages, read all 10 pages. If it's 50 pages, read all 50 pages. Have your attorney go over it, but even if your attorney goes over it, and I highly recommend you have an attorney read these agreements for you and help you with these agreements, you read it yourself as well and become familiar with the types of terms that you're being asked to sign up to, and make sure you can live with those terms. Don't just sign the agreement because you want the work and shrug your shoulders and think, well, nothing bad's going to happen. I can tell you from experience, something bad can happen and sometimes will happen. Never sign an agreement without thoroughly understanding it. So let's talk about the things that I used to see that I became very sensitive to when I'd be looking at these large agreements, and I would see these time and time again. Before I do, I want to reiterate, I'm not your attorney. I'm not giving you legal advice, so don't take this as legal advice. In these large agreements, the first thing I would look for, indemnification. There's always an indemnification clause. If you don't understand indemnification, go look it up or ask your attorney to explain it to you. But basically what it means is, if you hire me to do something, and I do something wrong, and you get sued, I'm going to defend you. And they'll oftentimes have language in there, large corporations say, you will indemnify and hold harmless our corporation and anything that has to do with our corporation, our officers, our affiliates, our subsidiaries, everything. Which basically says if any of those people get sued because of something you did, you will defend them. You will defend us, and you will bear the cost of that. Now, indemnification is a fair concept. If I do something wrong and you get sued, you shouldn't have to bear the cost. I should bear the cost. So there's a fair concept. But just make sure you read it and understand it, and make sure it's not overly burdensome or unfair. So make sure it applies well for what you're looking for. And the other thing I would usually do is turn it around. All right, if you want me to indemnify you, I want you to indemnify me. In case there's something that you do that I get sued for, you're going to protect and defend me as well. And sometimes we would win to get a corporation to sign up to those terms, because that's also fair. The other thing I would look for is intellectual property rights. Now, I had an asset. I had a large piece of software that we had developed and that I had the rights to. Whenever you sign up to do work for somebody, there will almost always be a clause in there that says that anything you invent, any idea you come up with, they own it. Rights to that idea transfer to them, because basically they paid you to come up with that idea. And again, that's somewhat fair. That is fair. If they paid you to do something, you came up with a new process that they now use, they don't want you coming back in a couple of years and claiming that you own that process, the rights to that process, and trying to charge them a royalty. So to protect themselves against that, they'll have that general language in the contract. Where it gets tricky is, let's say that you own a way of doing something, a process, and you come in, and in the course of doing business for that particular customer, you improve your process, you come up with better ideas, better ways. Do they now own those better ideas and those better ways such that you can't use them in your process? Or do they now own your whole process, your whole way of doing things? Make sure that language doesn't allow that. We would normally ask to put language in there that says that we already have pre-existing intellectual property, pre-existing ways of doing things, that we will employ those in doing our work for you, and any improvements we make, we own. And they were usually okay with that, but make sure the language says that. Someday in the future, you might want to sell your company. And someone who comes in and does their due diligence, they will read every one of your contracts that you have or ever had to make sure that, especially if you're selling an asset to them, some sort of intellectual property, to make sure that they now have the rights to that nobody's going to come out of the woodwork and challenge those rights. Make sure you never allow such terms in any of your contracts ever. Otherwise, you might find yourself unable to sell whatever it is you think you're going to sell when it comes time to exit your business. Another thing I would look at is insurance levels. Most large companies are going to require you to carry some level of insurance, and they'll state it right in the master agreement. They'll define the types of insurance they want you to carry, as well as the coverage limits. Now, some sort of general liability insurance, you should expect that. Then again, look at the coverage limits they're looking for. $1 million, $2 million, maybe that's okay, depends on your business. $10 million, again, depends on your business, but the coverage requirements may be excessive for what you're delivering for them, so negotiate that. A lot of times I would see errors and omissions insurance, E&O, very expensive insurance. Sometimes coverage amounts of up to $5 million. On a contract deal, it's worth maybe $300K. So I would usually negotiate those terms because that was an actual expense to me. Other things you want to look at is, what are the payment terms? A lot of large companies are going to try to push for 60 and 90-day terms now. You get paid 60 or 90 days after you invoice them. That's an eternity to a small business, so try to negotiate the best payment terms you can. Also, termination terms. Can they terminate for convenience, which means they can just kick you out anytime they want? And if they do you get paid anything for that? So make sure that the terms are reasonable for termination of the contract. Make sure you can get out of the contract. Sometimes the termination terms for you aren't even disclosed or spelled out. And so you certainly don't want to be having to deliver to a contract that becomes non-profitable for you or otherwise a bad deal for you. You have to have your ways of being able to exit that contract too. Make sure those ways are spelled out. The other thing I would look for is confidential information protection, non-disclosure language, NDA language. Most large agreements will have some form of NDA language built into them. I would often look to see if it's mutual. A lot of times it's one-sided. They want you to protect their information, but they don't say anything about protecting your information. I'd make sure that language gets in there. The other thing I look for is it reasonable what they're asking us to do to protect this? I mean, can we do this reasonably within our way of and our course of doing business? And then the next thing I would look for is there an end date to this? Sometimes the contract has an end date, but there's no end date on the NDA language. Make sure there's an end date on the NDA language. You definitely don't want to have non-disclosure responsibilities hanging around years and years and years after you're done doing business with a customer. That's another liability that you have to carry, and that's going to also be a deterrent possibly for someone who comes in and wants to buy you if they see that language still existing in a contract somewhere. So make sure up front that you don't even agree to open-ended terms like that. Always make sure there's an end date on anything you agree to. Other than that, have your attorney go over these agreements. Do not just sign an agreement just because you want the business and you don't see that anything bad is going to happen. Trust me, something bad can happen. You could end up in a lawsuit, or when it comes time to sell your business, whoever buys your business might find some term that they object to or it scares them away from the deal. So definitely read all agreements and have your attorney go over the agreements. If you like the content we're providing here, please follow us. And as always, if you have any questions, please direct those questions to info@brettscorner.com. I'll watch that email address and I'll respond to your emails. I won't respond to comments you leave on the video, so please use the email address if you have any questions or you want me to respond. And as always, thanks for watching.